was the very lack of forensic capacity we have in Pakistan by the vast majority of criminal justice actors, from the point of registration of the FIR with the police to the point of conclusion of the case before a judge. Even judges of the higher courts do not fully understand how this expanded definition is to be implemented.
Welcome to In Sync, a podcast about the lives we all want to really live and figuring out how to get there. This is a trigger warning for this episode. This episode contains significant mention of sexual violence, rape, and the laws related to it. If any of these topics are triggering to you, please proceed with caution or avoid listening. Hi everyone, welcome back to In Sync. I'm your host Anmol Irfan, and we're back with another episode, still connecting to last episode's theme of justice, but hitting a little closer to home. Our guest today is a lawyer, legislation and policy advisor, and most recently, researcher on the latest report by Equality Now, which focused on the legal response to sexual violence in Pakistan, as well as the challenges in enforcement and access to justice. Seems heavy? It is. But today's episode with Sahar Bandial, an advocate of the high courts with an over 12-year litigation practice, is to help us as everyday citizens break through those difficult-seeming terms and understand how laws like this affect our everyday lives. So Sahar, thank you so much for being here today and explaining the work that you've done. I'm so excited to have this conversation.
Hi Anmol, thank you for having me, and I'm looking forward to speaking to you today.
So just before we get started, you've had such an impressive career and you're doing so much amazing work, but I'm sure that you have your own perspective of, what you're doing and everything you've achieved. What is it that gets you out of bed in the morning every day?
Anmol, when I decided to study law and through these years practicing law here in Pakistan, I think what continues to inspire me about the profession is that it's a field where one can make a difference through your daily practice, be whatever nature of case or a legal area that you are practicing in. So I think that's something that continues to inspire me every day.
I'm so glad to hear that you are being inspired by what you're doing. We need people who are still invested in this process, especially with so much going on in our country regarding these laws. And, there's so many complications. And you touch upon that in the report that you've done. It's such a detailed report. I learned so much by reading it. One thing that I'd love to talk about, particularly of a topic that is considered so taboo, you touch upon this element that is, I think a lot of people don't understand, which is the gap between legislation and then the enforcement of that of justice through that legislation. Are there any findings that surprised you the most?
Anmol, I think there were various findings in this report and my research for this report that were surprising. Not because I had not thought about those issues as problems in the criminal justice system, but the very stark nature of them became more apparent to me. You see, the thing is that in the last, I would say, 9 or 10 years, there has been a lot of legislation on gender-based violence, particularly sexual violence in Pakistan. Amendment was passed in 2016, which introduced certain procedural protections for rape victims during the course of investigation and trial. And then we saw in 2020, through the anti-rape ordinances, which then matured into acts in 2021, a complete, I wouldn't say turnaround, but a great shift in the understanding of sexual violence and the procedures that apply in case of sexual violence. The definition of rape expanded to cover a range of conduct, including object rape, penetration of other bodily orifices. Clarity was provided as to the meaning of consent, that it should be unequivocal and voluntary and clearly communicated, that the two-finger test was and virginity testing was banned and prohibited and declared unconstitutional. References to a woman's previous sexual history were also prohibited in the course of trial. Anti-rape centers were to be set up, special investigating units were to be set up, etc. So I think the legal aspect, the law that governed rape offenses and sexual violence generally, saw a great shift, and I would say at least at the level of the law, great improvement. What surprised me was the level of disconnect between the implementation of these very progressive and commendable laws. So where there was provision for the conclusion of trial in rape cases within 3 to 4 months, our findings indicated that it takes maybe up to 2 to 3 years for the trial to be completed. Um, the definition of rape, although progressive now and in line with international jurisprudence and requirements under international law, has not been understood by the vast majority of criminal justice actors, from the point of registration of the FIR with the police to the point of conclusion of the case before a judge. Even judges of the higher courts do not fully understand how this expanded definition is to be implemented. So, there has been a great step forward in lawmaking, but various, I would say, infrastructural constraints and mindset constraints hinder the implementation of the law. For example, another very shocking factor for me, was a fact that came before me, was the very lack of forensic capacity we have in Pakistan. So you have cases that occur across all four provinces, but the two primary forensic agencies in the country are only in Punjab and in Sindh. And I learned during the course of my research that samples continue to be sent from KP to Punjab for forensic analysis. So these are swabs or any sort of trace evidence that is taken from a crime scene is sent from KP to Punjab. And the time period for reporting can vary from any time between 1 month to maybe like 4 to 5 months. What happens through a trial during the course of that waiting period? Um, the trial court continues to wait for the investigation result. The police continues to wait for the result of the forensics to frame their charge. This lack of capacity really feeds into the delay that our criminal justice system suffers and the ordeal of individuals who are waiting to attain justice. So I think in short, again to recap, I knew as a practitioner that there were so many gaps and sort of shortages in our legal system. But the very stark nature of it through figures and experiences of practitioners themselves became more apparent during the course of this research.
Thank you so much for detailing that. And I find it so interesting, like you said, that even for someone like yourself who's been in the system for so long, these things are still surprising because, like you said, these delays, they come out of the smallest sort of issues with infrastructure or access to justice. And on a broader scale, if someone is talking about these things, someone like me, for example, who's not as involved, will think, oh, we are making progress, but that progress might not be as fast or as effective as we would want it to be. And I think that there's still, because of these misconceptions or because of a lack of understanding, there's still so many misunderstandings around sexual assault and rape legislation in Pakistan. How do you address these in the report in particular?
I want to emphasize that there has been progress and one must acknowledge that progress and commend the state for moving forward, right?
Yeah.
The law on paper is just written word. It becomes effective and takes on a life only when it sort of is at the stage of implementation. And we do have human actors implementing the law. So the societal mindset and prejudices that play out in our daily lives equally impact and inform the implementation of that lettered law. So while it is important to celebrate and recognize the progress, it is also important to understand that the equation from lawmaking to implementation is not so straightforward. It is riddled with all these challenges of societal prejudices, infrastructural constraints, capacity constraints, etc. Now, in terms of addressing sort of misunderstandings about sexual violence that a layperson may seem to have, and especially the law regulating sexual violence, we seek to address that by highlighting, number one, what the law is. For example, many people would not be aware of the fact that our law allows room for prosecution of marital rape. The exception to the definition of rape was removed in 2006. The exception provided that sexual relations between a husband and a woman will not classify as rape, regardless of whether there was consent or not. It was worded differently, but that was the import of the exception. In 2006, when the law was amended, this exception was removed. So, technically, under our law, forceful sexual relations within a marriage, that is, sexual relations without the consent of the wife, can classify as marital rape. This is an opening in the law, but the judicial system, the police system has not really understood this opening, has not explored this possibility. So I think that's one real misconception, or I would say lack of information, that people do not know about the law. The other, I think, misconception that exists is this continued conflation between Hudud ordinances and the way Zina bil Jabr was defined under the Hudud ordinances, and rape as it exists now under the penal code. Just to give some context, that in 1979, when the Hudud ordinances were promulgated, the offense of rape was removed from the penal code and legislated as Zina bil Jabr in the Hudud ordinances. And the evidential requirement in the Hudud ordinance was that if a woman is to claim or establish the claim of zina, which is adultery, or zina bil jabr, which is rape, then she has to produce the testimony of 4 male witnesses of good character. If the punishment of Hudud is to be given, that evidential requirement no longer exists. Women can now file a complaint of rape under the penal code, and under our established precedent, established judgments, the sole testimony of a rape victim is sufficient for conviction, provided that sole testimony is confidence inspiring. That means that it is consistent with other evidences, with other claims. So you don't need eyewitness testimony. You don't need the testimony of 4 male witnesses. And this lack of confusion, or the lack of understanding, or this confusion, we continue to even see sometimes in trial court judgments, where courts are still continuing to refer to rape as zina bil jabr, or this was some case, I think in the early 2000s in Karachi, actually, the trial court dismissed, late 2000s, after the 2000 Act was passed. I'll redo this.
Okay. Yeah, Zoha, just redo this answer, please.
So the confusion even persists at the trial court level. We have judgments at the trial court level which continue to use the language of the Hudud ordinances, continue to refer to rape as zina bil jabr, continue to seek the eyewitness testimony of 4 male witnesses, which no longer is a requirement under the law. And I think this confusion must be addressed. Although I do want to add, and this is something that I want to talk about generally also, how even though we have moved forward in terms of law making, there is still some level of resistance that we face by the judiciary in progressive implementation of the law. Now, I explained to you how the Hudud ordinances were then amended and rape was re-legislated in the Penal Code in 2006. So part of that amendment in 2006 was that a conviction of rape cannot be converted to a conviction of adultery, which means that if a woman is to make a complaint of rape and she is unable to provide the evidence for the complaint that sexual intercourse was committed against her without her will and consent, her failure to prove that evidence does not mean that she has confessed to illicit sexual relations and therefore can be convicted of adultery. That sort of possibility in the law of conversion of a conviction of rape to one of adultery was categorically prohibited in the 2006 Act. And the Hudud ordinances were amended prohibiting such a conversion. But what we have seen in the last 2 years is that even the Supreme Court of Pakistan, in 2 cases or 3 cases, has allowed for such conversion. And I think we are again, the legal system itself is again not clear about this distinction that now exists between the hudud and rape under the penal code. And the prohibition against conversion is not fully understood and then being implemented by the Supreme Court. So I think, and more the confusion I want to emphasize, bringing my answer to a close, this confusion about what the law says and what it means exists not generally in society only, but also in our legal system, which is why we have very shocking decisions that come out from our superior judiciary.
Mhm. Definitely, I think there's been quite a few contentious issues that we've seen publicly as well, where a lot of people haven't expected that kind of understanding of the law, and like people like yourself who are experts and who are more aware have been questioning what's happening within our courts as well. And from a more layman perspective, for people who would like to read this report, like to be informed or empowered, what are some of the aspects that you feel could best benefit someone who is hoping to empower their own understanding of implementation of these laws?
I think the chapter on gaps and inconsistencies in the law, it's written in very layman terms. It is not just addressed to lawmakers or lawyers or judges or the police. It's addressed to anyone who wants more awareness about this subject, and to civil society who's working on this issue. The chapter on gaps and consistencies in the law itself looks at and explains existing definitions um, in the law, the meaning of consent, what consent means, why is consent such a contentious issue. And I think I want to spend a little bit of time talking about consent, because now what the law says is that consent for sexual relations has to be unequivocal and communicated through words and gestures. What we see across the board internationally also in cases regarding sexual violence, that the defense taken often is, oh, the woman consented, oh, she did not object, she did not scream, she did not protest. We have text messages from her showing that she flirted with us, for instance. I teach law at a university, and when we're talking about consent in a case in a criminal law class, that's one of the issues that a boy, of course, raised. That my question to them was, how is consent established? And he responded by saying, oh, looking at previous conversations and previous messages by a woman exchanged with a particular boy with whom she may be in a relationship. But that's not how the law is looking at consent. The law wants to establish consent, or seeking to establish consent at that point in time when the sexual assault exists. So consent can be given for a particular act but can then be withdrawn. At that point in time, when a particular act is undertaken, the question in the law is whether consent was freely and willfully communicated to the other party. So that is clearly clarified in the section on gaps and consistencies in the law. The second chapter, I should say, the second section of the report looks at procedure more generally, and what everyone, readers and those who are interested and those who may be affected by the law, should understand is that the law now provides various procedural protections. So an FIR must be registered by a police officer. So if there's any delay in registering an FIR in sexual violence cases, a complaint can be made against that police officer. The FIR is to be registered in the presence of a female police officer in sexual violence cases, or in the presence of a female relative. To facilitate victims, the police may actually even visit a particular place where the victim is comfortable to register the FIR. DNA testing must be done within a particular period of time. The law says preferably within 24 hours. A medical examination of the accused is mandatory now under the law. Trial can be conducted in camera, trial can be conducted behind screens, so you don't have to confront the accused. No reference can be made to the previous sexual history of a rape victim, though of course there are some judgments which say otherwise, but that has been the general sort of progression of the law, particularly through judgments, a medical legal examination has to be with the consent of the victim, and the medical legal officer cannot undertake the two finger or virginity test. Also, rape is a non compoundable offense, which means that parties cannot settle or compound the offense out of court. Rape is an offense against the state, and the state is duty bound to prosecute rape. These are some clarifications that the report provides. These are particularly clarifications regarding what the law is right now, but at the same time, the report identifies how, even within these what may be progressive provisions of the law, there's still so much that is lacking and so much that must be done to fully implement the law and have a positive impact on the lives of those who are affected, who are victims, who are survivors of sexual violence.
100%. And I think that can only happen when we continue to have these difficult conversations, and continue to do the work that you've been doing. But at the same time, I think it's important to acknowledge that this is very difficult work, and I'm sure especially as a woman more so. Is there anything that you find particularly hard working on topics like this, and how do you balance your own well-being when you are in the midst of these projects or these cases?
Yes. So, Anmol, I think just over time you build a thicker skin. Um, I remember my first exposure to a case of child rape and murder when I was interning at Asma Jahangir's office. This is a very, very long time back, before I started my full-time practice. And I can tell you that I was unable to sleep for very many weeks after seeing pictures and looking at the medical legal examination report. And I think over time, you just end up building a thicker skin without, of course, at least in my case, becoming numb to the suffering the people you are helping have been dealing with. My work is more on the civil side, and I will tell you that even in family court cases and in workplace harassment cases that I have more recently dealt with, there have been occasions where I have had to control my emotions, because the kind of questioning that is brought forward, or the victim blame, or the blaming of the woman that tends to often happen in our court settings, uh, affects me personally too. But then, of course, you have to pull yourself together, and I think develop a thick skin, as I said, but also the ability to control reactions, because reactions do come when certain things are said in court.
Yeah, I think that's great advice for anyone who'd be wanting to entering this field as well, and sort of gearing themselves up for what's to come. And I think just to wrap us up, for any of our listeners who haven't had the chance to read the article that we did on Sahar's work and the report for Echoes, I want to share a quote that she shared, where she said, "For survivors of sexual violence, accessing justice and support in Pakistan remains slow, difficult, often re traumatizing, and impossible for many. While legal reforms are a vital step, they must now translate into tangible, meaningful change in police stations, courtrooms, and communities throughout the country." And this really stuck with me, Sahar. So I think to wrap us up and leave our listeners with one final thought, what does this meaningful change look like in your eyes?
I think a commitment by the state, number one, to implement the law. There's been a lot of progressive lawmaking. There has to be emphasis on implementation. That implementation, number one, of course, requires resources and infrastructure, but at the same time, it requires a societal mind shift. And that societal mind shift can only come about through open conversation by the state on these issues and direct engagement with criminal justice actors, the police, the judges, medical legal officers, prosecutors, on what the law means. What are the legal standards that they have to abide by, and remain cognizant, while remaining cognizant of any biases, social prejudices that come in the way of implementing those legal standards. There has to be very open conversation, very open acknowledgement of the biases that impinge implementation of the law, and direct training of these stakeholders and actors of the criminal justice system. And I think, Anmol, one must be very realistic in terms of the timeline that we are speaking about. This is not going to happen overnight. Lawmaking might happen overnight, but implementation is definitely a process, and we must continue to remain engaged in this process, cognizant of our challenges and limitations, and directly engaging with those limitations so we each reach our end goal.
Thank you so much for that, Sahar, for sharing all your thoughts and for the work that you do. I'm sure that you have left our listeners far more informed than they were before and willing to, take the steps that they need to empower themselves and empower the people around them. So it was so lovely having you here. And to all of our listeners, thank you so much for tuning in. If there's anyone who needs to reach out to help, please, we would encourage you to reach out to support systems. As Sahar detailed just now, there is support available. And yes, of course, there's a lot of work to be done, but please do reach out to support systems to help to anyone around you. And if you know someone in need of help, please encourage them to take that first step. And as always, thank you so much for tuning in. We will see you next time with a new episode.